The government is under severe attack from Pakistan. A number of opposition parties led by the Congress and a group of hyperactivists and a number of Indian and foreign media publications for diluting Article 370. Almost on a daily basis, viewers, they scream at this government, at other patriotic Indians, for what they call is the crime of the century. Some of these individuals have challenged the historic decision to integrate Kashmir with India in the Supreme Court. A dangerous fake news campaign has been launched on social media to create an anti-NDA environment and influence the judiciary to rule against the Modi government. It's the judiciary which is being constantly singled out to show that even if this entire lobby of individuals were to go to the Supreme Court like they have done now, seeking the restoration of Article 370, they're unlikely to get justice because everything is fixed. A battery of top lawyers will now fight, as I said, to restore the special status of Kashmir in the Supreme Court in a few weeks. With all of this happening, does the government stand a chance? Does it have a strong case? You might have been bombarded with articles to suggest that the government has done a gross illegality. It has crossed all red lines of constitutionality. And you must be wondering if this is indeed true, if the government is running riot over the Constitution. As you know, viewers, there are two sides of the argument. And on paper, those that oppose the government have cited several Supreme Court observations and verdicts to their own advantage and claim that the government's move is palpably illegal. But today, that debate may be settled once and for all. But tonight we are joined by one of the finest minds, legal minds in our country. And I think this is the first time he will be speaking at some length on this particular issue. Mr. Salve, thank you for speaking to Times Now. I just want to begin by asking you whether you believe that the government has acted illegally, as the contention is.
No, I don't accept that position. My reading of the Constitution suggests that what the government has done is within the provisions of the Constitution. You must understand that while framing the Constitution, sub-article 3 of Article 370 made a provision saying the President can, by notification, disapply the Constitution or apply it with such changes or modifications as may be. If the Constitution is to be amended, for example, if a provision as significant as Article 35A had to be embedded in the Constitution, it would require Parliament 2/3 present and voting, Article 368, and it would be subject to the basic structure challenge. But Article 370 allows the President by notification to make adaptations to the Constitution, and including disapply the Constitution, disapply Article 370 completely. 370 sub-article 1 also allows the President to apply such parts of the Constitution with such changes, etc., which establishes that this was a special provision made to deal with Jammu and Kashmir. I don't want to join the political battle on whether this was temporary, permanent, semi-permanent, but as a constitutional lawyer, a provision which allows the President to modify the Constitution in its application to a significant part of India, i.e. a whole state of India, should be construed as being a temporary provision. And that's what its long title says. Now, whether politically over a period of time this became temporary or permanent is quite another matter, and I don't want to enter that debate.
Right. The Supreme Court in April 2018, on this point, said article, and I'll quote the bench here, Justice Adarsh K. Goyal and R.F. Nariman. They said Article 370 acquired permanent status through years of existence. This is making its abrogation impossible.
Because by itself, it is one thing for a court to compel a use of power under Article 370 to apply or disapply provisions of the Constitution. And if it has been there for 50 years, to tell a court that as a matter of judicial review, you must now compel the government to move around, is very different from a government which, if it takes a political decision that we now need to apply more provisions of the Constitution, or we need to apply the whole Constitution, is a very different situation. And that can't be equated with what we are talking about. So the judgment of the court was in a context, and that judgment has to be understood. It is one thing to say that the provision has acquired permanency of the kind that you cannot now direct the government to remove or not remove. It is another thing to say that a presidential order has acquired a permanency. That can never be. The whole idea of allowing the president to amend and modify the Constitution and its application was to provide flexibility. Article 368 is rigid, and it is meant to be rigid. Constitutions cannot be amended easily unless 2/3 of Parliament present and voting do so. And that is why the Supreme Court, right from 73 in Keswaram Bharti, said, you cannot amend the basic features of the Constitution. So any provision which, in a sharp contrast to the constitutional scheme, allows the president to make changes in the constitutional application to a state shows that there is need for flexibility, which means that the political situation in the state, and I don't mean politics in its narrow pejorative sense, I mean politics in its larger sense, that the political situation in the state was such that it needed to be adapted. Now, the government uses that very provision to apply the whole Constitution. I don't know how that can be wrong.
Let me break it down for you, sir. This is how it was done. It is, the government essentially construed the references to the government of the state with the governor and the constituent assembly of the state as per Article 370 as the legislative assembly. It has then made all provisions of the Indian Constitution applicable to the state following the recommendation of the governor, who is a central government appointee. The Legislative Assembly of J&K has replaced the Constituent Assembly, as you know, which no longer exists, but neither is the Legislative Assembly in function, so the centre can simply take the governor's word as the consent of the state. So basically, Article 370 does not stand abrogated. It still exists in the Constitution, but it has been completely emasculated as all provisions of the Indian Constitution, sir, have been made applicable to it, and J&K has lost its special status. Now, given this convoluted way of doing things, has the spirit of legislative consent been violated? There is no legislative assembly in function, sir.
So let me address the two issues distinctly. I don't know whether 370 has been abrogated or the Constitution, which had been abrogated in Kashmir, has been brought back into force. You can look at it either way.
That's a clever way of...
A lot of beneficial... It's not a clever way, it's a perspective.
Yeah.
If you start with a presumption that this was always how it was meant to be, and what has been done is morally wrong or politically wrong, then you start using adjectives like this has been abrogated, this has been emasculated, etc. I can equally argue the whole Constitution had been emasculated by 35A. 19(1)(c), the right to settle in any part of India, is basic to a federation. You took that away for Kashmir for forever. Why? So one can argue this, the wisdom of doing all this equally strongly from both sides. And there were problems in Article 35A. There is a judgment of the Supreme Court which recognized that there were those who, by the same token, should have been entitled to reside but were not residents, and they have been denied their right to reside in that state. So this sort of using of adjectives obscures the legal issues, and I'm not addressing the political issues. Personally, I'm for this, but I'm not addressing the political issues. I'm not a political expert. The legal aspects are, these are machinery provisions. These are machinery provisions which have imparted flexibility in otherwise a constitution which is robust and applicable fully. The flexibility itself is for political decisions to be applied in a state. That's why it says the precedent by order. It doesn't require the parliament to do anything. Precedent by order means the executive government of the Union of India. The executive government of the Union of India decides which part of the constitution applies or doesn't apply in Jammu and Kashmir. That was the extent of flexibility. If the government of India today says, let's apply the whole constitution, how can it be legally wrong? You may say, no, by a flux of time, people had been assured and you should not have done it. The should or should not is not an argument, which the court will go into, which I want to address. But this convoluted and this, etc., is all wrong. Now we come to the second issue, the assembly of the state. This has two dimensions. The assembly of the state stands dissolved, and it stands dissolved for good reason. There is no stable assembly of the state. Today, Parliament is exercising the powers of the state assembly. Parliament, by a two-third majority, has passed this law, has passed this resolution. Parliament could have amended 368 by using powers of 368 and knocked 371 out of the Constitution completely. Two-thirds present and voting have ratified these resolutions. So I don't see where this whole argument of bypassing a state assembly or getting past it applies. Parliament has been passing the budgets for the state. This is ultimately an important political decision. It has been applied in a manner which the Constitution permits. And I think it will be a grave blunder to superimpose the political arguments over the legal structure.
Two quick questions to you, sir. One is that why only an exception for Jammu and Kashmir when Article 371, as you know, applies to several other states of the Indian Union, also giving them a degree of special status? And secondly, on the issue of constitutional morality, some people have also said that Article 370 was untenable. What's your view on these two arguments that are thrown up?
See, as far as the first is concerned, there are states with special status, there are states with no special status. That has never been considered a ground of discrimination. Kashmir was given a special status because of its political problems. We know that historically. The other states have had other issues. Like, for example, the Northeast has had certain other issues. There are ethnic issues, there are border issues, there are economic issues. By its very nature, the Constitution, while it recognizes the power to create special states, to create special situations, tomorrow, if two-thirds present and voting Parliament wants to get rid of 371 and they feel that's in the national interest, they can. None of these I would read as part of the basic structure of the Constitution. That is why we have the power to amend the Constitution. I can understand if the government had done this as a pure executive decision without taking parliamentary approval, like the criticism of Brexit, that you made a constitutional change. That's why the English House of Lords, the English Supreme Court said that you have to go and Parliament must approve Brexit. And that's what has led to the mess in this country, the political mess which they are dealing with now. Now you can see our resolutions were placed before Parliament. Parliament, two-thirds present and voting has passed it. If Parliament feels tomorrow that this should go back to the State Assembly and they don't want to pass it, they will not pass this. So this consultation with the State Assembly is something which is a political check and a safeguard. If today the politics of Kashmir is such that there is no state assembly and there is no prospect of a state assembly, there are fundamental imbalances in the state. That is why Ladakh has been removed and created a separate union territory. And I have not heard any major criticism for doing that. If these basic changes made to that state are in larger public interest, I don't see any legal impediment in achieving these changes. This kind of elbow room must exist in constitutions. And if they are right or wrong, again, is a matter of debate and is a matter which ultimately must be resolved in the Indian Parliament.
On the issue of constitutional morality, do you believe that Article 370 was not in consonance with constitutional morality, sir? Many people have said that it engendered aberrations, gender discrimination, caste discrimination, several other types of social inequities.
I have, personally speaking, I have always felt that the reasons why Kashmir was granted this special status were somewhat tenuous, but at that time, there were a lot of things which we had to do to get the states to accede to the Indian Union. One of them was privy purses. All the princes and all the kings were offered generous privy purses. When the time came, the Indian Parliament said enough of this and discontinued it. So there have been a lot of things at the time of bringing in a state into existence or bringing the Indian Union into existence, which over a period of time we get rid of. See what is going on in Hong Kong. When the British tried to interfere in Hong Kong, saying under the devolution agreement, they have a right to intervene up till 2040. The Chinese said, sorry, no, once devolution is over, we are now a sovereign country, off you go. So these changes in the political structure do happen. And constitutional instruments cannot be construed in a manner which is so rigid so as to stand in the way of these kind of changes. That's not what they are meant for. Constitution instruments must be flexible. Otherwise, they put their own existence in peril. So this argument about constitutional morality is something which is to be seen in the context of the history of Kashmir. In any case, 370 uses the word temporary in its long title. And I personally feel allowing the president the writ of bringing in the constitution, removing the constitution, bringing in with amendments, including an amendment as dramatic as Article 35A, was a very serious power. And the sooner this power has been put to bed, the better it is.
Thank you, Mr. Salve, for speaking to me. It's been very enlightening, and I'm sure the viewers will take away the points that you have expressed and analyze them, and perhaps at some level or the other come to their own conclusions. Thank you very much.